Comenzamos el bloque informativo en Extra News.
Language of this particular statute. It says the president may call into federal service members and units that he deems necessary, right? So that is an express delegation of Congress's power to call up the militia to the president.
Well, it's in such numbers as he considers necessary, right?
Correct. So the president has the discretion to decide what level of forces are necessary to counter the threat. And the threat is in the last phrase of that first sentence, necessary to repel the invasion, suppress the rebellion, or execute those laws. And in the president's judgment, 2,000 National Guardsmen from California are necessary to execute the laws in California. And the record bears that out, based on the fact that we have declarants from ICE explaining that the National Guardsmen are essential right now to protect the federal buildings from additional breaches and violent rioting involving fireworks, Molotov cocktails, concrete chunks being thrown at ICE officers who are simply trying to prevent individuals from interfering with enforcement operations and trying to breach the buildings.
So suppose that we had a hypothetical where, suppose there was no violence, no organized opposition at all. Everything is calm in Los Angeles. And the president says, I've decided that there is a numerical target for the number of removals I would like to have. And with the number of ICE officers that I'm able to hire using the funds that Congress has appropriated, I can't hit that target. Therefore, I find that I'm unable to execute the laws, and so I need to call up the National Guard under Section 6. Setting aside, I understand your first line argument that the judgment is completely unreviewable. Do you think that would meet the definition of unable to execute the laws?
It certainly could be. Again, it would fall within the president's discretion based on the facts available to him. If we're in a world where this is not reviewable, then that would be a decision that the president could make. And if it's an abuse of that authority, there are measures or means by which the other branches, Congress, can check that decision. But I think the conditions also suggest some type of intervening event rather than an election, right? Like an invasion in the first prong suggests there is some type of activity that interferes with the security of the United States. The second prong, a rebellion that rises up. The third prong, some external force or activity, right, that requires the president to act, not an election. But again, I think that would be within the
mere dissatisfaction with the level of the regular forces that Congress had provided would not be enough under that definition.
Well, I wouldn't want to concede that, Your Honor. I think that would be the president's decision based on all the facts available to him, and the record may support it in a particular case. But obviously, that's not what happened in this case. The president acted. So
counsel, let me ask a question based on Judge Miller's hypothetical. So let's take a look at the facts that Judge Miller posited, and let's say that the problem was limited to California, that there was nothing to suggest that the problem was beyond California. In your view, if a hypothetical future president made the decision to call up in response the militia of every state and the District of Columbia, so 51 militia, would it also be your view that that decision by this hypothetical future president would be entirely unreviewable?
Yes, because the statute says the president may call into federal service members and units of the Guard of any state in such numbers that he considers necessary. That is an express delegation that couldn't be any more clear, that the president gets to decide how many forces are necessary to quell the rebellion, to execute federal laws. But again, bringing it back to this case, that of course that's not what he did in this case. He only called up 2,000 National Guardsmen. The Secretary of Defense found it was necessary to call up an additional 2,000. And the facts on the ground have justified that decision. Those guardsmen are necessary on the ground today to prevent breaches of the federal buildings, to protect ICE officers when they are conducting their law enforcement operations. The guardsmen are not conducting law enforcement. They are charged with a protective mission, not a law enforcement mission. I'm happy to talk further about the conditions, but I also like to talk about the second issue that the district court focused on, which was whether the Secretary of Defense committed a technical violation of the statute by not issuing the orders through the California governor. As you know, the district court found that the Secretary of Defense committed a procedural footfall by not issuing the orders through the California governor. But under the statute, the governor is merely a conduit, not a roadblock or a co-executive when the president decides that it's necessary to call up the guard. And in this case, the Secretary of Defense complied with Title 10 by issuing the orders through the governor via the Adjutant General in California, who is the governor's chief of staff for these purposes and is delegated authority under California law to issue orders in the name of the governor. And I think the facts bear out that that was the right decision and the right procedure to follow, because the California Adjutant General followed the order, forwarded the order to Governor Newsom, and the order was complied with. The whole point of this element of the statute is to ensure that there's a smooth handoff in the forces from the state.
Counsel, I'm going to ask a variant of this question to your friend when it's his turn. Do you read in the district court's order on this point a definitive statement of what it was that the secretary should have done to comply with this supposed requirement that obviously the district court found that sending it to the adjutant wasn't sufficient? But do you see, how does the United States interpret the order in terms of the specificity of this wasn't enough? How does the United States interpret the order of what would have been enough to comply with this?
I think it's unclear. It's unclear whether he meant that we should have copied Governor Newsom on the email, but he didn't say that. But he agreed with us that, and disagreed with California, that the statute does not contain an approval requirement or a consultation requirement. But at the end of the day, I think that's what the district court imposed by saying you can't issue it through the adjutant, you got to issue it through the Governor Newsom, in which case, what's the point, right? We're going to get to the same place because the governor has no discretion under the second prong of the element sentence of the statute. He shall issue the orders, right? So even if we sent that email to Governor Newsom, we'd get to the same place. He would be required to send that order to the adjutant, and we'd be in the exact same place today.
I understand the United States' argument. There was no technical violation here, but even if there were a technical violation, the remedy imposed by the district court was all out of proportion to the supposed wrong.
Exactly, right? So at the district court here, and we even asked the district court, if you think there's a technical violation of the statute, give us a chance to cure, right? We'll send the right email, whatever you think we need to do, we can do that. The district court did not give us that opportunity. Instead, the court issued an extraordinary injunction that basically vacated the president's decision, orders him to reverse his order and surrender control over a portion of the armed forces back to the California governor. That is an extraordinary order and remedy, wholly out of proportion. And under the Winter case, really the equities here are totally imbalanced for all the reasons we've explained in our declarations, given the mob violence and the threats that if this order goes into effect, it will be putting lives at risk and federal property at risk as well.
So, counsel, you may not know the answer to this question, and it may not be in the record, but I'm asking about sort of current conditions. As the United States has pointed out, the proposed order that the state asked the district court to impose says in it that the order doesn't prohibit the force from providing indirect assistance to federal officials, protecting federal property, defending federal officials or employees from threatened physical harm, etc. Is right now, are the forces doing materially more than what was in that carve-out that the state had proposed?
Yes, Your Honor. And I think that's clear from both the Nell Declaration and the supplemental declaration from General Sherman that we submitted just with our reply brief. It explains not only are the guardsmen protecting the perimeter of the federal buildings, but also performing kind of an escort function when ICE agents go outside of the federal buildings. They are setting up a perimeter so those officers aren't assaulted by mobs when they're trying to enforce federal immigration laws. So even that proposed order would have been an extraordinary intrusion as well.
So even if that proposed order had been entered, the United States would, as of now, be doing things that would have been barred by that order.
Yes.
Okay, thank you.
In your view, is there any issue under the Posse Comitatus Act before us in the current posture of this case?
No, Your Honor. The district court ruled for us on that issue at this stage. In the TRO opinion, I don't understand the state to resurrect that argument for purposes of the stay. I'm happy to address it, but I mean, the point that we made in district court was that there is no violation of the Posse Comitatus Act. The orders are very clear that the guardsmen and the Marines are engaged in a protective mission that falls within the president's inherent power. They're not engaged in direct law enforcement. And I think the declarations from Nell and the other general that we submitted made clear that the guardsmen and the Marines are carrying out those orders faithfully, consistent with statute.
But your view is that there's no need even for us to say that much because the issue just isn't here.
That's correct.
Counsel, did you want to, and I know we've asked a lot of questions, did you want to briefly address, or however long you want to address, the 10th Amendment issue?
Your Honor, I don't think there's much to say because I think it's completely derivative of the statutory question. I think the district court ultimately recognized that at the end of that portion of his opinion. I think the state recognizes that as well. If the president acted consistent with the statute here, then he's acting consistent with the Constitution because the militia clauses authorize Congress to delegate to the president the authority to call up the guard. If he permissibly called up the guard, of course, there's no 10th Amendment problem here.
Yeah, I read the district court's order as I believe you do, where the district court explicitly recognized that if the district court had gotten it wrong on the president's authority to call up the guard, that the 10th Amendment calculus would be materially different and might well weigh in the president's favor.
I think that's right. I mean, there's no 10th Amendment issue here if the president is acting consistent with the statute. I'm happy to answer any further questions. If the court has no other questions, I'd like to talk about kind of the situation on the ground in Los Angeles today and walk the court through some of our declarations, unless the court has any other questions on those statutory issues.
I'm fine with your doing that, and I know Judge Miller and Judge Sung will ask questions if they feel it appropriate, but I'm fine with your turning to that.
Thank you, Your Honor. I just want to emphasize how crucial the Santa Cruz declarations are. It's at the first one is at page 235 of the addendum. The second declaration is attached to our reply brief, and it explains the danger right now on the ground in Los Angeles to federal officers and property from the mob violence and disorder. Paragraph 7 of that declaration, the original one, explains how a violent mob tried to prevent ICE officers from conducting immigration enforcement operations in Los Angeles on Friday, June 6th, immediately prior to the president's invocation of this statute. Paragraphs 9 through 17 then go on to explain an extremely dangerous situation involving violent and riotous demonstrators threatening to breach the federal building in Los Angeles that evening, where ICE was detaining illegal aliens and federal officers were pinned down and severely outnumbered. It also explains how federal officers had to hold the building by themselves because it took over an hour and a half for local authorities to provide support and assistance to the federal officers. Paragraphs 18 through 20 describe what happened Saturday, June 7th, the day the president issued the order. 7 hours of constant fighting nonstop between ICE agents and a violent crowd that disrupted an immigration enforcement operation planned for that day. One officer was trapped inside her vehicle. Another shattered his or her wrist because of concrete blocks that are being thrown, mortar-style fireworks. Paragraph 33 of that declaration, I think, is essential here. It concludes, quote, "I believe the safety of local federal facilities and the safety of those conducting immigration enforcement operations in this area of responsibility requires additional manpower and resources," end quote. That was a week ago. The supplemental declaration confirms the situation on the ground has not changed. There's still ongoing violence and an extraordinary need for the Guard in Los Angeles even today. Paragraph 4 explains that the federal building in Los Angeles, the one that had been breached the week before, has still been closed since June 9th. And again, concludes that the guard is essential to protecting that property. Paragraph 6, I think, is also crucial. It explains that there are continuing violent protests at federal facilities throughout Los Angeles, including this past weekend. June 14th, there were 1,000 people assaulting law enforcement, a violent mob with rocks, bricks, fireworks, an extraordinary scene. And that declaration concludes in paragraph 7 through 14 that the guard is essential to continuing to safely enforce immigration laws and protecting federal buildings in Los Angeles. I just commend to the court, it is essential that this injunction be stayed, otherwise lives and property will be at risk. The court has no other questions.
All right, do you want to reserve the remainder of your time?
Yes, thank you, Your Honor.
All right, we'll now hear for the attorney for the governor in the state of California.
Good afternoon, Your Honors, and may it please the court, Samuel Harbert on behalf of the governor and
Let's start first with the Martin case, which there's some discussion of that case. The point I want to make is that that decision is both controlling and remains good law. It's controlling because the statute in that case is very similarly structured to the statute at issue here. The Act of 1795, again, started with a wherever clause, and it had one condition, invasion. And if that condition was met, the president could call forth the militia. Here, the statute also starts with a whenever clause. It also includes the invasion prong, but it also has two additional elements. And it concludes with a delegation to the president that he may call forth the guard if in his judgment it's necessary. So I think in deciding a reviewability question, you look at the language of the statute, not factual distinctions on the ground. Yes, in that case, it was an invasion, it was a foreign policy matter, but this statute also, that's before you hear, Title 10, also invokes foreign affairs powers and the president's domestic powers as well. And it's also remains good law, right? We cited the Dalton case, which was a 1990s decision that invoked the same principle, where a statute is drawn in a way that delegates broad discretion to the president. Courts don't just defer to the president's judgment. Courts don't review the president's judgment. And that's what we have here. And in that case, it was a domestic matter, not a foreign policy matter. So Martin would not be just limited to foreign policy matters. The second point I wanted to make was the easiest path to a decision here is on the third problem. The president made a determination that he is unable, based on with the regular forces, to execute the laws of the United States. The record certainly bears that out, not only in his proclamation, but also in the declarations made clear, and the plaintiffs have conceded there is civil unrest in Los Angeles, but not just ordinary civil unrest. Civil unrest is targeting federal law enforcement officials and designed and aimed to prevent them from carrying out their duties. The court should at least defer to the president's judgment under prong 3. And then finally, on the through language, I think the plaintiffs have an extraordinarily dangerous interpretation of that statute. Under their reading of the statute, Governor Newsom could pocket veto the president's orders, not convey them, and wait for somebody to come down to Sacramento and consult with him before he issues that order. That is not what the statute says. The statute says through the governor, doesn't say by the governor. We've cited other statutes that are similar that contain the consultation language. This statute does not contain that language. In sum, Your Honors, we would ask you to grant our motion for a stay pending appeal. If you deny our stay pending appeal, we would ask the court to give us an opportunity to seek emergency relief from the Supreme Court. Thank you.
All right, we thank all counsel for their helpful arguments, especially on an expedited basis. We thank counsel for appearing remotely. I would also simply note that the panel is cognizant of the fact that you have another hearing set on Friday before Judge Breyer. And again, thank you. And with that, the court is adjourned.
Muy pronto, vuelve a escuchar las noticias más relevantes en este canal de noticias.